Today, after 40 days of arguments, the Supreme Court finally concluded its hearings in the Ayodhya title suit case and reserved judgment. There was some drama in the court, but the actual proceedings were overshadowed by the fact that the main Muslim litigant in the land dispute, the Sunni Waqf Board, signed onto a settlement agreement. The key aspect of this agreement is that it has agreed to drop its claim to the land on which the Babri Masjid stood for centuries before vandals from the Bharatiya Janata Party and other Hindutva organizations demolished it in 1992, provided, and this is its principal demand, the other side agrees to protect the status of all other places of worship in India. What does the Sunni Waqf Board's offer mean? And what does the Vishwa Hindu Parishad's refusal to accept this offer mean? More importantly, what impact will the settlement agreement, which the Supreme Court has yet to endorse, have on the court's handling of the case? These questions form the subject of today's episode of Beyond the Headlines. Since there is so much confusion and motivated disinformation, let me start by explaining what the Ayodhya dispute actually is. The Babri Masjid was built in Ayodhya by the Mughal Emperor Babur in 1528. There are no contemporary accounts of the prior existence of a Ram temple in existence at the spot, let alone a temple dedicated to the birth of Ram. There are no contemporary accounts of Babur demolishing a temple of any kind to build his mosque. In the 19th century, during British colonial rule, the dispute first surfaced when some Hindus who believed the spot was where Ram was born clashed with local Muslims. Thereupon, a platform was erected outside the domes of the mosque called the Ram Chabutra, where Hindus worshipped while Muslims prayed inside. And matters remained peaceful till December 1949. That month, as Krishna Jha and Dhirendra Jha have documented, the Hindu Mahasabha, working through Abhiram Das and others, surreptitiously planted the idol of Ram Lalla inside the mosque. They were driven by the same frenzy which drove Hindutva fanatics to assassinate Mahatma Gandhi in January 1948. The agenda: communalize society and weaken the Congress's hold over the country. The masjid was promptly locked and Muslims barred from entering it. Cases and countersuits were filed on the question of ownership and control of the site, but essentially the matter went into cold storage till the Congress government of Rajiv Gandhi moved to have the locks opened in February 1986 as part of its politics of using religious polarization as a means of holding on to power. A few months later, it passed a law to overturn the Supreme Court's verdict in the Shahbano matter, a move intended to appease Muslim chauvinists in the same way as it had appeased Hindu chauvinists with its Ayodhya move. Now, it's the nature of communal politics that the Ram Janambhoomi issue was promptly grabbed by the BJP, which used it to mobilize support across India on communal lines by pitting Hindus against Muslims. The strategy worked miracles, and the BJP, which had won just 2 seats in 1984, saw its tally climb to 85 seats in 1989 and then 161 seats in the 1996 elections, when it promised for the first time to build a Ram temple at the site of the Babri Masjid as part of its election manifesto. Of course, on December 6, 1992, the party leadership mobilized lakhs of supporters and got them to actually demolish the mosque that day. At this stage, 3 distinct legal processes emerged. First, a criminal case was filed against senior BJP leaders Lal Krishna Advani, Murli Manohar Joshi, Uma Bharti, Vinay Katiyar, Kalyan Singh and others for their role in the demolition of the mosque. Second, a parallel commission of inquiry under Justice M.S. Liberhan was set up to look into the circumstances leading up to the demolition. And third, the Allahabad High Court was seized of the title suit, in other words, the civil dispute over who owned the land, in which 3 primary parties, the Sunni Waqf Board, the Ram Janambhoomi Nyas and the Nirmohi Akhada, claimed full rights. Nothing much happened till 2009 when the Liberhan Commission submitted its report nearly 17 years after the Babri Masjid's demolition. The next year, in 2010, the Allahabad High Court delivered its verdict in the title suit, giving each of the three parties a one-third share in the land. The parties then promptly moved the Supreme Court in appeal. But 27 years later, 27 years after the demolition, the third and most important legal process, which involves punishing the criminals who conspired to demolish the 16th century mosque, remain unpunished. The demolition of the masjid took the lives of hundreds of people in the All India violence which followed, but the Central Bureau of Investigation, which is the agency tasked with prosecuting the case, seems to have had no interest in this crime. This brings me to the present. I have no idea why, of all the important cases of life and death, the present Chief Justice of India saw fit to fast-track the title suit appeals, setting up a 5-judge bench of the Supreme Court, no less, and holding daily hearings. But that is what happened, and now judgment has been reserved. Chief Justice Ranjan Gogoi retires mid-November, and the judgment is likely to be delivered before that. We have no idea which way the verdict will go, but we now have a complication by way of this settlement agreement which the Sunni Waqf Board has signed along with a number of the Hindu litigants, but not, and I need to underline this fact, the Vishwa Hindu Parishad, which is the main power behind the Ram Janambhoomi Nyas and of course Ram Lalla, the juridical personality of Ram, who is also a party to this case. The proposed settlement revolves around a simple proposition. The Waqf Board says it will consent to the Babri Masjid land being used for the construction of a temple, but wants a guarantee that there will be no further demands placed on the Muslims of India. The fear is a legitimate one. At the height of the Sangh Parivar's campaign against the Babri Masjid in the 1980s, the slogan that they had popularized was, "Ye to abhi jhanki hai, Kashi Mathura baki hai." In other words, that after Ayodhya, we will press on with demands to take over 2 mosques in Banaras and Mathura as well. Since then, other demands about the Taj Mahal, about Qutub Minar have been made, but let's forget about those for a moment. Now, let me leave aside the moral standing of a compromise when one side is decidedly unequal and under enormous pressure. We know that the governments of India and Uttar Pradesh are openly partisan on the Mandir issue, and it is absurd to believe a fair out-of-court settlement is even theoretically possible. When the parties are unequal, a settlement is a bit like a protection racket in which powerful goons divest honest citizens of their rights in exchange for the privilege of not being attacked. But forget about that for a moment and ask yourself what the VHP and the Sangh Parivar's refusal to give the Waqf Board a guarantee that they will not make further demands means. Frankly, I would never trust such an assurance from the Hindutva groups, but the fact that they are not even willing to make such an assurance is the surest indication of both their arrogance and their intention to press ahead with their communal politics even after the Ayodhya issue is settled. This itself should put paid to the illusion that peace can be bought by appeasing such elements. I know many Muslims who are despondent and feel that it is better to appear magnanimous. General Shah is one of those who recently spoke out, Zamiruddin Shah, but they forget that we are dealing with a political formation that is driven by the basest possible instincts and by an ideological agenda that believes non-Hindus have some kind of lesser claim to India. This politics needs to be confronted politically, of course, but when it breaks the law, as it clearly did in 1992, it must be held to account in court. And this brings me to the Supreme Court's options. Now that the Sunni Waqf Board has proposed a settlement, will the court accept it and dispose of the case? Or will it go ahead and begin deliberating on the arguments presented before it over 40 days and deliver a detailed verdict? Quite frankly, we just don't know. The court could use the settlement agreement as an input for its final verdict, or it could disregard the document altogether. As things stand then, it could do one of three things: uphold the Allahabad High Court verdict, which gave a one-third share to all three litigants, or it could alter that verdict in favour of the Hindu litigants, or it could do the same in favour of the Muslim litigants. Ruling in favour of the Hindu litigants, or even upholding the High Court verdict, means the construction of a Ram temple covering either the entire or a major part of the disputed site would become a reality. BJP leaders have also said the centre could pass an ordinance to build a temple if the court verdict is ambiguous. Either way, the apex court must state that no construction should take place till the criminal trial in the demolition case is over and blame fixed for the crime committed on December 6, 1992. Second, and this is very important, none of the individuals or organizations associated with the crime of demolishing the mosque should be allowed any involvement in the construction or management of any temple or structure that ever comes up at the disputed site. We know the adage, crime does not pay, and a political crime must certainly not be allowed to generate political dividends for the criminals. This is an obvious benchmark that any civilized society ought to embrace. And India, don't you know, is one of the world's oldest civilizations.